The law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program, as we tell you, has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We provide information and resources each session that will help you decide whether or not you need or want to contact a lawyer. Perhaps will help you determine that you can handle some issues yourself. If you do want additional outside counsel, you'll be better prepared, and so will the professional you select. Either way, of course, our goal is to help you save time, money, and achieve the best possible results. We want to, as always, thank the Bazar and Associates law firm in East Providence and welcome them. Thank you so very much, David Bazar, for helping us with the various issues that we tackle each session. So today, we're going to continue on more of the questions that you ask every day. We have some answers. Last session, we addressed some legal issues about how to respond to police, how to say you're sorry without actually saying you're guilty, or even how to handle the medical marijuana issues that might affect some of your job prospects. So today, money, scams, divorce court, even your obituaries, all of these kinds of things can cause you some trouble. So we're going to help you grapple with some of them, some scenarios and anecdotes, and of course David always has some great legal insights. Let's start with money, of course. I thought that Social Security was sacred. People ask, can creditors actually get to your Social Security benefits? Is that at all possible?
So it depends on the exact situation you're talking about. But for the most part, there is some protection against creditors with Social Security disability, SSI, of course, and perhaps even retirement account, but a little bit different. But sometimes people ask the question, I'm getting divorced. Is my Social Security protected in a divorce? And in Rhode Island, it's a very interesting answer. If you get divorced in Rhode Island and you have just gone on to Social Security disability, for example, and you get a retroactive benefit, the benefit and the lump sum that you receive are not considered property under Rhode Island law. And that's based on federal law, that it's not property, it's income. So if you get a $10,000 retroactive lump sum, that does not go into the pot, so to speak, as determining what marital assets are. So it's not subject to equitable distribution, and it's protected. However, if child support is being calculated, you then include it as a monthly benefit for each month that you received it for when calculating child support.
So if you're getting divorced and you are delinquent on your court-ordered child support, can the court tap into the Social Security if you're collecting it?
So for purposes of child support, probably even alimony, yes, because it's be considered income, and you can use your income or assets to satisfy a judgment. And even if it's just your asset, it is your asset, and the court can say, well, you have an asset available to satisfy the child support.
Interesting. So while we're talking a bit about divorce, is it possible for you to disinherit your spouse before things happen?
So again, using Rhode Island law as the basis at this point in time, you can, however, any property that's in your name alone, and by property I'm talking real property, real estate, that you don't leave to your spouse and you don't have otherwise protected through some other mechanisms you can use, such as a joint ownership with somebody else or something that takes it out of your name, then that property that you die with in your name goes through your estate. And under Rhode Island law, a spouse has a life estate interest in any real estate that you own at the time of your death. So while you can disinherit your spouse, there are provisions in the law that provide a way for the spouse to get back at your assets on an elective share basis. But there are mechanisms to plan around even that.
So I'm imagining that that's certainly something that if it happens to you, you'd probably need to have a lawyer. I don't know that that's something where you could dare say someone could handle themselves. They probably need to have a lawyer when their way through that
That's not
mess.
A do-it-yourself kind of thing.
And you can, of course, disinherit your children. Do you need to be very specific about who you are disinheriting on the one hand, but also why? so that you don't have it contested
Well,
if it's will
you
versus...
don't necessarily have to put the why into the will, but it's certainly helpful that there's a knowledge base as to what's going on and why. But the law only requires that you know when you execute a will who the bounty of your estate would be, in other words, who would naturally inherit from you, and that you know what your estate is and that you have the cognitive capacity to execute the will, which is, again, in Rhode Island, a very low standard. You don't have to know who the president is that particular day, but you have to know who your children are.
Yes.
So that being said, if you don't want to include a child for whatever reason, you simply can say it's intentional, it's not a mistake or oversight, I'm doing this, and the lawyer can know the reason if you want the lawyer to know, and probably should. But you don't have to necessarily spell out, this person's never seen me, because I think once you start spelling out things, it's sort of like a little opening in the door for them to dispute that. Oh, no, that's not true. I did see my dad every week, and every week that followed this will, so he would have wanted to change that. You don't have to spell it out.
So it's actually better to not do it.
Probably.
I've heard people say that it was better if you did, because then it would give them less reason to say we can challenge this effectively and make hay out of
And
it.
again, in Rhode Island, it's very difficult to challenge a will if the person had the cognitive ability to exercise their own judgment and do what they were doing, so there's no duress, which is one of the reasons you could challenge a will, or undue influence or whatever. But I can see the argument both ways. I don't think it's necessary, but I can see why you might put it in. But again, when you put it in, that might just give that person who's being left out more ammunition than the other side of the story, where they say, oh yeah, I know I didn't see him and I don't want to bother with it.
Okay. More on the money and divorce issue. If you're getting a divorce, who pays the mortgage? Both names are on it. Both are supposed to be responsible for it. How does that work out? Is it ultimately just the person who ends up living in the house? So how does that work out, David?
Well, so typical situation where there's a house in joint names and the mortgage is in joint names and all the other bills are equal, taxes, insurance that go with the house, equally responsible by each party to pay. You look at the totality of the situation and what stage we're at in the divorce. Are we at the stage of temporary allowances, which is the beginning of a divorce? What are we going to do until the divorce is final? Oftentimes, parties just stay in the house during that period of time, and they just continue doing what they were doing before the divorce was filed. Sometimes, one party or the other wants to move out, but they still want an interest in the house. They don't want to say just, yeah, you take it, you pay it, it's yours. They may want an interest in it. So I've seen a lot of judges take different routes to what we do with that. So one route would be is husband, say, moves out, wife is still there, and he's now paying rent somewhere else. She's living there. So I've seen judges say, okay, let's take what the fair market value of the rent is, for instance, to stay in the house, and have her pay that, because she's paying her rent, he's paying his rent, or her share of what the rent would be. And then whatever the difference is, split it between the parties so that he's contributing towards it and she's contributing towards it. There's a lot of assumptions that go into that both
Sure.
parties are making, similar income perhaps, that they have similar expenses outside of that, so that it's just a fair and equitable way to do it in the interim. Sometimes one spouse or the other may be making most of, not all, the income, and then that person's probably going to be paying it until you decide what to do in the divorce. Now you get to the point of the divorce, and there's again a number of different things that can happen. If there are younger children in the house and you want to keep them in there for a period of time, you might do what's called a deferred sale. That's where the person who's staying in the house, mostly with the children, or primarily with the children, would want to stay, for example, until maybe the older child graduates or the younger child from high school if they're close, so that that doesn't have to change and be a disruption in their lives while this is happening. And then after that happens, the house is sold. Again, what you might then do is have the spouse who's not living in the home contribute to some of the expense of the home, so that when the house is sold and they're going to split the equity equally, there's a fair and balanced reason for doing that. You may set the equity now and say, when the house is sold, this is what that spouse is going to get, but the spouse who's in the home is going to be paying all the expenses going forward. So there's a lot of different ways that you could resolve that issue.
So one of the questions that came up in tandem with that is, okay, so the wife, say, stays in the house, and she's therefore going to be responsible for the mortgage and she doesn't pay it. The husband's name's still on it. What recourse does he have? What do they do?
So oftentimes there's provisions in the agreement, property settlement agreement or court order or whatever it might be, that if the spouse that's responsible for paying the mortgage who's living in the house and doesn't pay the mortgage, then that triggers the house being listed for sale.
Ah. And to a lesser extent, suppose she doesn't pay the cable bill,
Right.
and both names are on it. And the cable company goes to the husband and says, no, you can't shut it off, it's in arrears. What
Right.
happens in those cases?
Again, there's usually an order that one spouse will indemnify and hold the other spouse harmless on the bill and that they're responsible, so you can file a contempt motion to bring them back to court to have them ordered to pay. So there's a number of things that can go into that, as there are a number of other issues that would go into, like the deferred sale on the house. We talked about triggering it for non-payment if one party's supposed to be paying. Oftentimes, spouses will want some other triggers in there. For example, if both parties agree, well, then we can just naturally agree to sell it earlier. Or if it's a concern of one spouse that the other spouse not have somebody else living in there who's a romantic interest, you can say if you have someone who's cohabitating, or if you remarry,
Okay.
those are triggers to do it. Remarriage is one that is particularly used because it's easy to know what the trigger is, and oftentimes it's, I don't mind my spouse living there, but I'm not paying or waiting
her next.
for her, new spouse to be able to live there on my dime, so to speak.
Got it. So what happens in credit card situations where one person fails to pay the bill? Address it if it's in the marital situation, but also if you're just a single person who failed to pay the credit card bill. What happens?
So in the marriage situation, when we divide up debt, oftentimes if the debt's in your name and it's your bill, you pay it, the other spouse may pay theirs. Some joint debt, you might divvy up equally or some portion of each paying it. And then there's a court order in that situation to say who's going to pay what. And what can really flow through a lot of these issues, in a divorce in particular, is a bankruptcy concern. So if it's my spouse's obligation to pay those bills and my name's on some of them, I want to make sure that they can't file bankruptcy and discharge my obligation, and discharge their obligation and have it come back to me. So the bankruptcy law does provide that a lot of debt and dealings between spouses, child support, alimony, that type of thing, are not dischargeable in bankruptcy anyway. And there is jurisdiction in the family court to go back to the court and say, they're filing bankruptcy, but I want it ordered that they still have to pay this bill. And if they don't pay it, they're in contempt. So there has been a lot of litigation in those areas on those issues.
Good to know. Well, let's change just a little bit here. You've dealt with wills and estates, and those can be traumatic issues. So apparently there are issues about what you need to do when someone dies. You take care of some of the assets, but if someone writes an obituary, apparently it can cause trouble. It opens up the case that someone could hack into your credit cards, your Social Security, to fraudulently open up credit cards. What do you do? This isn't specifically about a will and estate, but when people ask about what did I do wrong? All I did was list that my spouse died, and here are the number of kids and the date and time and place. We're not going to be in the house, which then gets robbed, but that's another story. So what do you tell someone, or what would you advise someone to do to avoid being targeted as a scam, as a victim of a scam?
Interestingly enough, it's my understanding, I don't have direct knowledge of this, but I've been told that when you make your funeral arrangements, you can actually pay a little extra and have a fraud alert protection built into that whole process, so that if you die and you have the fraud alert arranged for through the funeral home, your Social Security number and all of those things are protected from misuse by other people, just like you could hire it while, sign up for it while you're alive and do that type of thing. And it also has a provision in there that, on the other thing, that you can, a recommendation that they make that if you list, the dates and times of the funeral and so forth, that you hire someone to stay in the house or have someone else stay behind so that that's being watched as well.
So that the house is never unoccupied.
Correct.
So if they didn't, so this seems to be fairly new that you can sign up in advance to have a fraud alert put on something. So otherwise, the surviving spouse or the children of the deceased would be falling upon them to notify Social Security with the death certificate, every credit card company that they had, every debt collector.
Yeah, I think this process that I'm hearing about involves taking care of all of that, including notifying Social Security about the death, because obviously if someone's receiving benefits, they end on your death, and so they need to be told. So all of that generally is covered with that process that you can purchase when you arrange your funeral.
Okay, and on a softer side of it, often when people who are interested in scamming are reading the obituaries, they will decide that they will call and say, I'm your grandson, granddaughter, you don't recognize my voice right now, I have a cold or whatever, I'm being arrested, please send money. How do you help a grieving spouse, grandparent, friend, whatever, how do you prepare them for that?
Yeah, it's just a conversation I think that you have to have, that you may get a call or expect a call. Refer it to, a child or somebody who will know better and deal with it. Because we've heard of those scams where I'm in Europe and I lost my wallet and I need you to wire me money.
Exactly.
And, it doesn't have to even involve a funeral or anything like that. These scams just happen. So just have a conversation with your older parents or relatives that need to know. If you receive a call like that, refer it to me. I'll take care of it for you.
And many people have life insurance, and often the life insurance company will be saying, well, we'll be sending you your whatever. But also, the other side of that, the life insurance scams, your husband took out a very large life insurance policy. That's terrific, but you just need to, he didn't tell you about it, but you just need to pay this very significant premium or the taxes or the handling fees. Someone who is unaware or vulnerable or emotional or any combination thereof, very likely to be duped there. How do you intercept that along the way or before it happens?
So there is no fee that has to get paid out by the recipient of the life insurance. So if it was legitimate, you would say, just send me the forms and send me the money that's due me, and if there's any filing, what did you call it, handling fees?
Handling fees.
Or whatever, they can take that out of the death proceeds, the death benefit.
It's amazing how creative people can be. The credit card reporting companies, so many retailers have been hacked. They'd say you're going to be given a free credit card report. Come to find out, and I'm sure you've read about it, I think Equifax is one of them. Others, I guess, too, have had issues. But the credit card reporting company has been hacked. As a result of that, the fallout is casts a much wider net than I would have ever imagined. But people have been asking now, I'm not even online, so Attorney Bazar, what do you do considering I'm getting a notice from saying that my license has been hacked and I should call Equifax immediately? Well, Equifax was the one that was the source of some of those things. So where do you put your finger in the dike to deal with that? Do you call the registry? Who do you call?
So if they're talking about a driver's license,
which then accessed a lot of information, other information, once someone had the license number.
Yeah, so I don't think the registry can do anything if your license has been hacked into from some other source and is being used for something. If there was a question about your license, then you're being sent something that says your license is being suspended and send us money and we'll keep it reinstated. No, then you call the registry because they're the only ones who can suspend your license it's not done by a private company or some other source like that. But be aware if someone says you something that looks like it's the registry, make sure you look up the registry number yourself and call directly to operator control or whoever it would be that would be in charge of that aspect of your license, and find out, is this legitimate? Is this being sent to me or not? So that's one thing to be aware of. As far as what else you can do, it's usually the credit reporting bureaus that you have to go to to fix that information.
So
And
what happens
that's
now?
who you have to go to for a lot of it. And if it was because of their mistake, they should be responsible for making sure that they help you fix it.
And for those who never had an issue about identity theft, they thought, because they were never online, they thought that this couldn't possibly happen, but to find out in large numbers apparently that it had, I think that as I had heard about it in this context, that Equifax actually called and asked people to give them their license number so they could verify the account, and then while that was being done, Equifax was being hacked at the very, in their own websites and their own databases, which certainly made for more difficulties than they would have imagined.
And so that is what I heard as well. The problem is you think you're protected because you don't have an online presence and there's no, Facebook or whatever else you might have that, online bank, you don't do this, you don't do that. But your information is online through credit bureaus and other things where you might have had to give information that they store. So you can still be affected.
When you need to do this credit card repair, license repair, Social Security repair, it certainly is a daunting task for most people. What do you say, or what would you suggest for, say, an elderly person who gets this kind of notification? You know that they are alarmed, to say the least, and they may or may not be equipped to slog through Social Security, credit card companies. Is there anyone they need to go to? Is it just a lawyer? What do they do?
Yeah, if you don't have, I was family member first.
Yes.
So if you have a family member who's can be helpful, that's the first place I would go. If you don't, then I think maybe a lawyer is the next best place to go. To me, it's always the next place
Of course,
to go.
of course.
But yeah, that's my answer to that.
So, honestly, is that something that it's one call, for those who have to do it, it's a call to a lawyer, to you or whomever, and then it's numerous phone calls that you have to make to credit card companies, all of those credit reporting agencies, Social Security, and do you get to find out how much damage is done and then help them watch the credit card statements that are going to be coming through in the next 3 months or something?
I mean, there's some of that can be done. It depends on the issue. If it's just an ongoing, I want to monitor the situation, there are actually legitimate credit protection bureaus out there that you could use. But again, I would have, if I didn't feel comfortable if I was older or somewhat compromised and couldn't do it myself, I'd have a family member check it out and find out what's the best way to protect myself and use the most legitimate company. And they're out there. Those are sometimes the best way to go.
Good. Let's talk about not people who do bad things, but those who do good things. How about Good Samaritan? For years, I can remember it's a good thing to be taught first aid. You can administer first aid, and under the Good Samaritan law, which means if I did something wrong, that I wouldn't be held legally accountable for it. Good Samaritan laws have changed. Do all states have them? What's the status of that now, David?
It's state to state, and how they're applied is variable in each state. But for the most part, the theory that or the way you proposed it is correct, that the law wants to encourage people to provide aid when they can. And so if you do it and something doesn't go right, but you're acting in a reasonable manner as anyone providing aid would do, then you're generally protected. There's always a question, and so this has come up with if I'm a doctor and I go and I try to render aid and I'm not successful, am I held to the standard of a doctor or just some other Good Samaritan? And it depends, where you are and what rules are in the state that you're doing it in, which is why sometimes people in the medical profession hesitate to jump in the middle of something, but they shouldn't. They should, because for the most part, you just render the aid and there is protection.
So considering there are so many people who are worried about the opiate-related issues right now, does that change when it comes to a Good Samaritan law? In other words, if someone thinks that that person needs Narcan and has it because in other circumstances they might have needed to use it, are they able to administer Narcan or whatever other drugs or paraphernalia that are needed to help assist? Is there a wider allowance for doing that when you might not actually know if that person is having a drug-related issue in an emergency situation? How does that play out,
Yeah,
David?
it's a very interesting question, and I think it's really just a further development along on what a Good Samaritan would be protected by and allowed to do. And again, probably state by state, but for the most part, if you have some training to recognize what the issues are and you have it available, you're probably better off trying to save a life than not. And so I think you'd be protected.
If you are making a call and you reasonably think that this is an emergency situation and you're reporting in whatever they call good faith, does that change if, for example, you decided to make that call and say it's of in good faith, but actually there's a cop around the corner that's about to arrest you? So in other words, does that nature of that call for an emergency situation change if you are either blocking or obstructing justice perhaps by making that call, by stopping everything that's going on, or by just saying that there's a you find out later that there's a police officer who's about to arrest you and you call for help and everything stops?
So let me follow the situation a little bit more. Are you talking about like a narcotics situation?
Yes, very specifically staying with that.
Yeah, and so I understand the situation. There is some laws in some states where if you're proactive about it, then you're not supposed to be arrested.
Yes.
That's what you're referring to?
Yes, if that happens, that's one scenario.
Right.
Continue that one, yes.
And so you're saying, well, can you be arrested if you're being proactive because the reason you're being proactive is you know that you're about to be found out or arrested or whatever. I'd say I think the law would still favor you being proactive and trying to get the help that you need. So what I remember is that if you were in a situation where someone was going to either be very ill or die from drugs or whatever, that there was protection for you to call 911 to get help right away. I think there were some laws that were passed that provide some protection in those situations.
Yes.
In some states. So I think if you make the call, you still would be okay.
It's good to know. We've certainly covered quite a few different topics. We hope that this has been helpful to you. We thank you for tuning into the Law Matters. Stay tuned because the law matters to you.